Welcome to Hello UPSC channel. Today I am going to continue with the discussion related to the National Commission for Minority Educational Institution. So in this we are planning, already you know very well that from yesterday onwards we started the program of 10-10. So till the preliminary we are planning to give the more information related to the 2023, and after that also we are going to continue with an idea of 23 mains and 24 preliminary and all. Okay, so this is the first topic, and the topic is regarding the National Commission for Minority Educational Institution. It also appeared in various newses and all. So there may be a possibility UPSC may ask a question related to this one. Okay, so when I'm going to start the first point, as per Article 30 of the Indian Constitution, is very clearly saying that the way how the concept regarding the linguistic and religious minorities, and the way how they are utilizing the principles of fundamental right, even 29 and 30 is completely, but the educational institution, that is the most important thing, to establish and administer the educational institution of their choices. So for this purpose, it was in 2004 the Parliament of India passed a bill in the name of Minority Educational Institution Bill, and also passed and got the approval from the assent from the President of India. On the basis of that, this Act, National Commission for Minority Educational Institution Act 2004, came into exist from 2005 onwards. So when I'm going to look into the second point, the way how this commission, when I'm looking into the process of the commission, generally there may be a possibility UPSC may ask a question regarding this. It is a quasi-judicial body, and the way how it is given some kind of power, on the basis of that this body is acting like a civil court. On the basis of that, what are the disputes are coming before this body, that body will handle related to the no objection certificate, related to the existence of the minority institution and other various purpose. But apart from this, this body is having some three most important function in the name of adjudicatory function, advisory function and recommendatory function. So on the basis of the three role, adjudicatory and advisory and recommendatory, on the basis of that, this body is functioning like a quasi-judicial body. Then when I am continuing the next level, the way how the jurisdiction of those we discussed so far. Now, when we are looking into any kind of body, people will have some kind of doubt that it what kind of jurisdiction those bodies are having, like the Supreme Court is having its original jurisdiction, appellate jurisdiction and all, advisory jurisdiction and all. The same way, when I'm looking into the concept of the Judicial Bill Act, on the basis of that, this commission, as per the Supreme Court verdict in the case of the Sisters of Joseph Cluny versus the state of West Bengal, 2018, the Supreme Court gave some kind of confirmation. On the basis of that, this commission, National Commission for Minority Institution, is having some kind of concept in the name of original jurisdiction as well as appellate jurisdiction. So it can able to handle both original jurisdiction as well as appellate jurisdiction as a part of the commission and its own methodology. So based on that, when I am moving further, there are some more possibility UPSC may ask. When I am looking into this provisions of the National Commission for Minority Institutions, Educational Institution, very specifically 2004. So there are some kind of concept. This body has created on the basis of the central law. The Parliament of India made this body. When I'm going to look into this body, there are some kind of consideration we have to give under Article 246 and 254 that I will explain as the last point. So now the case is that when the problem regarding the central law and state law, in terms of the implementation of the National Commission for the Minority Educational Institution, then automatically the central law will be prevail against the state law, and based on this kind of idea, as a continuation of the Article 246 and 254, it is very necessary the state government cannot make any kind of alteration, amendment or anything related to this acts. That is the most important thing. So based on that, when I am continuing further, the way how the concept regarding Article 246 and 254. Now there are some kind of methods that other than the Supreme Court of India and the high courts of the various states. under Article 226 and 227. And apart from this, no other courts inside our country other than Supreme Court and High Court shall entertain any kind of suit or application or any other proceedings in respect of any order made by the commission. So the commission's activity cannot able to interfere by any other court other than the Supreme Court of India or the High Court of the various state under Article 226 and 227. So this is the way the National Commission as having a civil authority as a civil court, and apart from this, by the way how the Supreme Court in 2018 gave some kind of appellate original jurisdiction, based on that it is really acting like a independent body to taking care of the minority educational institution under Article 30 of the Indian Constitution. Moving further, there are some other provisions also there. When the concept regarding this commission and its functioning, no suit, no prosecution, or any other legal proceedings can lie against the central government or this particular commission or the members of those commission or the chairperson of those commission or secretary, any other officer or any kind of capacity a person who is having within the commission's range, and what are the things they done it for the category of the good faith or some kind of intention they are having to strengthening the mechanism of the minority educational institution under this act can be questioned by anyone else. That is the most important thing under the sixth point. Then when I'm moving further, the way how some other provisions, like these are the very common idea. When I'm talking about the Minority Educational Institutions Act, the way how previous years UPSC also asked something regarding the office of profit, nowhere defined in our Indian constitution, or the concept regarding granting aid, nowhere defined inside our Indian constitution. The same way, when I'm looking into the idea of minority and minority related institution, now I'm going to, and minority is a point, is a term, is not properly defined or nowhere defined in our Indian constitution. But still the constitutional provisions are giving some kind of approval for the existence of religious and linguistic minorities. So based on this idea only, even the central government, you note it very carefully, the central government notified 6 religious minority communities in the name of Muslim, Christians, Sikh, Buddhist, Parsi and Jain. These are all the 6 community will under the religious minority category as per the for approval of the central government of India through the notification they issued inside the country. Then when I'm moving further, this National Commission for Minority Educational Institution also need to have one chairperson and generally 3 member, sometimes based on its volume and the capacity can able to handle throughout the country regarding various cases and all, the membership may go to 3 to 4, and all the members are nominated by the central government of India on the basis of the qualification. If a person is going to appoint as a chairperson, then the qualifications are like he should be the member of the particular minority community and he has been a judges of High Court for a person who is going to be appointed as a chairman of this commission. And suppose the government want to nominate someone as a members of this commission, and definitely the conditions are a member of minority community on one side, a persons of eminence and ability and integrity from the point of view of the central government. Based on that, they can able to appoint the people into this kind of area. So generally 3, sometimes 4, way the things will happen. Then when I'm moving to the next, what are the other things? When the commission is going to function, definitely the funding mechanism is necessary and consolidated fund of India you are going to make. So any kind of expenditure the commission is going to take care and that should be properly done, need to be in the name of accounting mechanism and relevant document, everything they need to prepare on the basis of the annual statement and prescribed by the central government after consulting with the idea of Comptroller and Auditor General of India. And those auditing mechanism will be properly audited by the accounts will be properly audited by the CAG, the way how the expenditures are going to incur from and payable by the commission to the Comptroller and Auditor General all. So based on that, the expenditure part will be done by the CAG, Comptroller and Auditor General. And final point, when I'm going to look into the concept of Article 226, The way how the High Court is having ability to give instruction and order and all other things in terms of, and 227 is talking about High Court's power in terms of superintendent of various tribunals and court, and 254 is inconsistent between laws made by the parliament or any other legislature, and 246 related to the 7th schedule of the constitution in terms of union, state and concurrent list. So this is the way the things is going to happen. Thank you all.